Hello everyone. Today we are talking about the case Fallas versus Mourlas. This is the group assignment of business law. We are four people in the group. Introducing myself, my name is Sabina and I will be talking about the executive summary in the case. Talking about the overview of the case, Alexander Fallas, the defendant, accidentally shot his friend Con Mourlas, the plaintiff, in the leg. The plaintiff and the defendant were among four friends who had driven from Sydney to Bathurst to spotlight kangaroos, downing a couple of beers with dinner before commencing the action. The fact about the case is that four men, including plaintiff and defendant, went for the spotlight recreational activity. Plaintiff agreed to hold the spotlight from the vehicle. At some stage, the vehicle stopped and the defendant climbed out of the vehicle with a handgun to join two other men. While the plaintiff continued to drive, defendant returned to the vehicle with the loaded gun even after plaintiff asked him not to enter the vehicle with loaded gun. Defendant assured that the gun was not loaded and that it was safe for him to enter the vehicle. The defendant began clocking the gun backwards and forwards in an effort to unjam it. As the defendant was doing this, he pointed the gun towards the plaintiff. There was then an accident discharge of the gun, resulting in the plaintiff being shot in the leg and suffering injury. This is all about my part, and now I would like to call my friend Srijana for the rest of the other part.
Thank you, Savina. Hi, it's Miss Rijana. Now I'll be continuing the rest of the part. So I'll be talking about the decision that the court made regarding this case. So at the trial, the plaintiff contended that the defendant was liable to him in negligence of the damages he has incurred. One of the grounds on which defendant denied liability was that he was entitled to the immunity under Section 5L of the Act. DCJ upheld the plaintiff's claim and found that the defendant has been negligent. Her Honor was not satisfied that the activity being undertaken at the time the plaintiff was shot was a dangerous recreational activity as defined by Section 5K. Further, Her Honor held that the plaintiff didn't suffer harm as a result of the materialism of an obvious risk of a dangerous recreational activity. According to Her Honor concluded that Section 5L didn't assist defendant. Her Honor handed down a verdict and judgment for the plaintiff in the sum of $98,467. So, with the divisions Section 5L are defined in Section 5K provided. In this division, dangerous recreational activities means recreational activities that involves a significant risk of physical harm, and obvious risk has the same meaning as it has in Division 4. In this summary, IPP and Tobias JJA held that the activity that plaintiff was engaged in was a dangerous recreational activity within the meaning of S5K. IPP and Bastian JJA held the risk that materialized didn't constitute an obvious risk of the dangerous recreational activity defined in Section 5F. IPP and Bastian JJA held the appeal should be dismissed with the cost with Tobias dissenting. The Court of Appeal essentially addressed two issues: is spotlighting is a dangerous recreational activity, and was a risk that materialized an obvious risk. So the rest of the part, my friend Aman will continue.
Thank you, Susanna. Hi, my name is Aman, and today I'm going to say about two issues highlighted by the court. The first one is recreation activities about sport lightning. In the particular circumstances of this court, there was a significant risk that one of the men, while leaving or entering the vehicle as a plaintiff was operating the spotlight, might handle a loaded gun in a negligent manner and cause someone in the vehicle to get shot. Therefore, the activity the plaintiff was engaged in carried a significant risk of physical harm and was dangerous recreational activity within the meaning of Section 5K. And the other issue highlighted by the court is about obvious risks, and according to IPP judge advocate, it was obvious risks is of being harmed by the conduct of the person of Section 5L to become relevant. The obvious risks must at least be of negligent conduct, and the defendant's conduct comprise of failure to take steps to ensure that there would be no accident caused by the handgun, as plaintiff already requested to be careful, but the eventful shooting was a gross negligence on the part of the defendant, and in the circumstances which defined risk by Section 5F. And by this, I want to conclude my topic and let my friend Melina continue the rest of the topic. Thank you.
Thank you, Aman. Today I'll be concluding about this case. In summary, this case evidences that there is likely to be confusion and disagreement as to the application of S5K and S5L of the Civil Liability Act. Each case will of course turn on its own facts, and wide range of opinions are likely as to what constitutes a dangerous recreational activity and whether there is a materialization of an obvious risk or not. According to the court, TCJ upheld the plaintiff's claim and found that the defendant had been negligent. Her owner was not satisfied that the activity being undertaken at the time the plaintiff was shot was a dangerous recreational activity, as defined by S5K. Further, her owner held that the plaintiff did not suffer any harm as a result of the materialization of an obvious risk of a dangerous recreational activity. According to her owner, concluded that S5L did not assist the defendant. Her owner handed down a verdict and judgment for the plaintiff in sum of 90,467. Thank you so much for watching our video.